chat.
Sounds great.
All right. So good afternoon and happy Friday. Thank you for joining us for our second in our Entrepreneurs Bootcamp series. It's an educational series for the faculty, staff, student, and community on what to expect when expecting a startup. So it's all the nuts and bolts outside of R&D and marketing. So I'm Matthew Savari. I work at New Ventures. New Ventures is the office in TDG dedicated to startup formation and support. You can visit us at tdg.ucla.edu/UCLA researchers /startup in a box for more researchers, for more resources. Today, we're joined by Matt Bresnahan, a partner at the San Diego and Los Angeles law firm, Wilson Sonsini. He's going to be giving us an overview today. He's been good enough to agree to give us an overview today on intellectual property and what that means for your incipient startup. So the way that we'll structure the meeting today is that I'm going to ask Matt to walk through the slides that he's prepared, and then we can save the Q&A for the end. So with that, I'm going to stop sharing and hand the share over to you, Matt.
Great. Thank you so much, Matthew. Let me see if I can share my slides here. Looks like you might need to transfer it to me for the share screen, Matt.
Okay.
There we go. Perfect. Thank you. All right. Now, Matthew, are you seeing the slides move on your end?
I am.
Okay, good. Sometimes it freezes. So excellent. Well, let's jump in. I think we have an hour. Is that right, Matthew? So
Yes.
Cool. And then in terms of questions, just at the outset, if anyone has any, happy to field them as they come. And will they go in the chat box, or do you want to just stop me, Matthew? Whatever you like.
So I'm going to ask if you have questions in the process of your presentation to just use the Q&A button. It's at the bottom of the screen, and I'll filter them appropriately, and
Cool.
then we'll make some space at the end of the hour.
Yeah,
as well.
sounds good. I'll plan to stop with 10 minutes for that, and I really would love to have questions as we go through it. So feel free to filter them as they come up if you'd like. Great. So thanks for having me. As Matthew mentioned, my name is also Matthew. I am a patent attorney and partner in our life sciences practice at Wilson Sonsini law firm with offices around the world and a significant presence in Southern California. I am based in San Diego most of the time. In normal times, I spend quite a bit of time in LA, typically one day a week. I think Tom Lipkin used to think that I actually lived on campus at one point several years ago. So very eager and excited to get back on campus as soon as we can do all those sorts of things, and very, very much thrilled to have the opportunity to present this virtual seminar on IP strategy. As I mentioned, I tend to focus on life sciences quite a bit: therapeutics, diagnostics, medical devices, digital health. Given my background as a biochemist before I went to law school, 15, almost 20 years ago now. But that said, the concepts that I'm discussing today on what an IP strategy is really are applicable across the board beyond life sciences, for sure. The nuances may differ, and when you might file a patent might differ if you have a software application for a new app, for example, or a robotic device, compared to when maybe you might file for a therapeutic drug. But nonetheless, the core principles are the same, and the application always has nuances for every specific IP strategy for every technology and every company. So my hope is at the end of the time today, the end of the hour, all of you will understand the core requirements for obtaining intellectual property protection beyond just patents, but patents as well. And a little bit about freedom to operate, I think might be helpful to understand what that concept means, and when you might be expected by investors and partners and other stakeholders to have a clear go-to-market strategy. That's essentially what FTO means. And yeah, very excited to be here. So why don't we jump in? My contact information, by the way, is here. So if at any point anyone has questions after today or later today, feel free to email or call. The office line now goes to my home office, so feel free to use it. Okay, so we're going to talk about creating an IP portfolio and other forms of IP protection, freedom to operate, and if we have time, a little bit on university licensing terms, which is part and parcel with an IP strategy, especially for a university spin out, which many of you may be contemplating. I'll go past these slides quickly. The one that I will focus on, beyond the fact that we're a huge firm, we don't let the size in any way suggest that we're not working with small companies every day, because we absolutely are. We've worked with companies like Google, like Genentech from the very beginning, two examples, one in the tech, one in life sciences, from the very earliest days. So a good portion of my clients, about 100 or so I work with, a good portion of those are the vast majority, I would say, are Series A, Series B range in their financing cycle, 6 or 7 public companies, and a good 20 to 30 very early stage companies, people literally in their garage, so to speak. Some of them actually are, especially these days, to just a virtual company with just a handful of people that have significant operations by way of their consultants and the like. So very broad firm, and really the way I would think about it is an opportunity for startups to leverage deep resources and network that the firm has across the board, and especially with investors as well. A little bit about my group. The one slide I'll go to quickly is this slide's important. We do a lot of university spin out work. UCLA, a lot of these companies are on UCLA. Aragon, a company with Mike Jung that one of the first university spin outs I ever worked with 13, 14 years ago. Octant's another more recent one. Sri Kasuri's lab, Rick Kaner's stuff's on here. So a lot of university spin out work we do. And then the last background slide, my group is the largest life science patent practice in the country. We have 180 patent professionals in about 11 offices. And we're also the largest in Southern California, between San Diego and LA. We have about 60 dedicated life science patent professionals, which would include patent attorneys and patent agents. So a very deep bench. It's pretty much any technology area you could think of, we have expertise in, and again, especially life sciences. All right, so let's jump in. So why are we going to talk about IP strategy? Why is it important? Well, as you all are probably aware, it's a very hot financing market. Valuations are as high as ever. Surprisingly, perhaps, if a year ago you asked me where we would be today, I would not in any way guess where we are, which is essentially doubling if you look at the total VC investment in the last year, which already was high. If you look at the graph going back 10 years, it's almost doubled every year, and last year was no different. I would not have expected that at the beginning of the pandemic, but nonetheless, that's where we're at. And as a result, and because the valuations are so high and investments are increasing, especially early stage investments, investors are becoming more and more virtually intolerant to any risk that they foresee in investments, despite there being high valuations and lots of available liquidity for their investment. Right? They see IPOs happening, they see M&As happening. They are still intolerant as ever. So it's critical that when you are forming a company, especially if you're going to seek institutional financing, that your IP strategy is airtight and rock solid. And I'll talk about what that means, but essentially, in short, it means that you have a clear FTO strategy to the market. That is, you can explain to the investor or partner why it is that you're not going to be sued when you launch your product. And also that you have a patent portfolio, whether it be company created or in license exclusively from a university like UCLA, which puts out more spinouts than anyone. And it's a pleasure to work with them. Either way, however you get your exclusivity, whether it's through in-licensing or ownership, you need to convey that piece as well. FTO, first piece, second piece, equally important, your own portfolio, which would prevent somebody else from copying, right? Because an investor on the first piece isn't going to want to come in and invest $10 million in your seed or Series A round if when you get to the market, you're going to get sued, right? That is, all that money is going to go towards lawyers fighting patent litigation. It's not why they're investing. They're also not investing so that when you get to the market, somebody copies you, right? That's the other risk that they're trying to hedge against by doing significant diligence early on. So therefore, the second issue, your own patent portfolio is what comes in to help somebody, help an investor understand that there is a lesser risk for somebody copying, because if they do, they would be sued for infringement themselves. So we have to get this part right. Before we jump into patents, just briefly, IP generally is the topic, and there's other forms of intellectual property protection that are also important in addition to patents. And inevitably, a company, whatever space you're in, life sciences, tech, software, whatever it might be, you're going to encounter multiple forms of intellectual property. Maybe you have a patent, maybe you don't. Patents are useful for quicker, better, more efficient mousetraps, for example, right? Utility, things that have functionality that are improvement and in the end provide better products and services for consumers and patients or whatever sector you're in. We'll come back to that. Trade secrets are important. Trade secrets are essentially any valuable information that a company has, it owns, it has rights to, that it has taken steps to maintain the secrecy of. So that could be something as simple as a customer list. It could be something as complex as a very detailed manufacturing process for manufacturing a device. Generally, though, internal to the company, not consumer or business facing, because at that point, once it's made public, it's no longer a trade secret. So here we typically use contracts, NDAs, proprietary invention assignment agreements with employees, consulting agreements that are strong and protective for consultants to ensure that what we have under lock and key internally at a company stays that way. All patents start off as trade secrets, right? Prior to them being filed as patent applications, the subject matter that's described is a trade secret. So inevitably, every company is going to encounter some form of trade secret protection. The way you do business could be a trade secret. Copyrights are also a very important aspect, especially in the software space. Software code is eligible for copyright protection. That's somewhat of a newfangled, relatively speaking, if you go back in time to the original Copyright Act. Software is a newer form of eligibility. The more traditional forms of copyright protection would be artwork, right? Literary works, paintings, any type of musical composition, lyrics, and certainly, artistic creations of any sort. So could also be a dance recital, an actual right to perform is a part of copyright. Typically, we see copyright more in the form of software in the technology arena. But of course, from time to time, there is rights to certain data that also copyright protection could come in. Trademark is more of a commercial consideration. Trademark law is all about allowing the creator of a brand to prevent consumer confusion, and also to encourage the investment of goodwill into the business by way of the company having some understanding and expectation that once a company develops a significant following, that somebody else won't be able to come in and confuse those consumers as to the source of the goods or services. So generally, trademarks is more for logos, for branding, for product names, for company names, but not functional in nature. Think of it more as a way to distinguish your product or service from the next one. And we want to encourage that, right? We don't want to be confused as consumers. You want to be able to know that when you buy a Range Rover, because it has that logo on it, you're getting a Range Rover, if that's what you like. Or when you go to the sporting goods store and you buy a pair of your favorite sneakers, you're getting that brand that you think you are. And then the last one to talk about FDA exclusivity briefly. There's lots of ways in the life sciences space that a company can obtain exclusivity for its goods or services. particularly in therapeutics, but not exclusively. There are ways that the FDA will preclude others from following on and obtaining approval for a drug product, for example, that references your data package. Also for orphan indications, pediatric exclusivity, there's all sorts of different ways that the FDA has come up with to incentivize new specific types of products for particular patients that are in particular need, based on the ordinary cost benefit dynamics of a company. May not be incentivized to go that route. Now, all of these forms of IP are very important, as I mentioned, and inevitably you're going to encounter multiple of them, 2 or more, I'd say at least. That said, patents tend to be the most important form of IP to an innovative company, right? That is, you may register your name, trademark it, put some thought into your creative product name, trademark that, protect your information internally under lock and key, make sure everybody signs NDAs, your trade secrets are there. Understand you have some copyright protection in your website design and maybe some software code behind it. But at the end of the day, the value of most innovative companies, biotech companies, tech companies, most emerging growth companies, is going to be found in their intellectual property and particularly their patents. And so therefore, we'll focus most of our time today on patent protection. But what I don't want anyone to think is that's the only form of IP, because it's not. And certainly for certain companies, other forms of IP will be more important. But for the most part, most innovative tech, biotech companies, patents tend to be the most important, especially early on. I have a slide here, and I'll make sure everybody gets these slides, by the way. Matthew, feel free to circulate them. This just shows a little bit of the relative value in terms of protection versus cost for each of the forms of IP. And I went through all of this already, so I won't repeat it, but generally speaking, copyrights are the least amount of effort and cost to obtain. In fact, once you've created an artwork in what's called a tangible medium of expression, it could be anything. That's just what the courts have come up to define when the trigger is, provided that it's original and within one of the statutory classes that we went through, artwork, things like that, you're going to have protection for it automatically. You don't have to register it in order to have protection for copyright. There are benefits to registering, but you have it automatically. Trade secrets, also automatic protection. Once you have the idea created, whatever it might be, provided that you've maintained its secrecy or at least taken steps to do so, and that it is secret, you have it as a trade secret. If somebody misappropriates that or steals that trade secret from you, you could stop them from using that and get it back, and they would be liable for damages if they caused you harm. But absent that, and strictly in the trade secret setting, if another company independently creates the same idea and does not in any way derive it or rely or steal it from you, then in that scenario, you'd have no recourse, and that would be free game. And that is exactly why we tend to file patents on our ideas and not merely keep them trade secrets. Trademarks would be the next level because it does require an examination process through the US Patent and Trademark Office to get a federal registration. You can certainly obtain common law rights by way of using the brand immediately upon use, but the stronger presumptive nationwide rights are only obtainable through a registration process that is substantive in nature in the United States at the USPTO, but not as intensive as, say, the patent examination process. And we'll talk a little bit about that. That is by far the most costly and also typically affords the greatest amount of protection on the continuum. All right, so let's come back to what an IP strategy and patent strategy looks like. Right, again, it's conducting an understanding of the landscape to have an FTO strategy, and it's obtaining patent protection for your product or service. So whenever somebody says, do you have a patent strategy, that is what they're referring to, if they know what they're asking. All of this is designed, especially at the earliest stages, to help the company attract investors, close that investment, and ultimately, for everybody's interest, help secure an exit later on, right? So secure financing and enable the exit strategy that everybody has in mind Whether that changes or not, that's a different story. But at least early on, the plan is this is why we're filing these patents. This is why we've looked at all the patents in the landscape, and here's what our strategy looks like. So let's go through requirements for patent protection. And then we'll look at what a lifecycle strategy looks like for multiple patents in a portfolio, and FTO, and then a little bit on university licensing if we have time. But licensing is really its own subject and a whole hour just to that. But the main point there is, if we don't have time to go into more detail, is really that the inventions that are created at UCLA should be disclosed to the TDG office, right? And then to the extent that you're interested in forming a company around those ideas, the TDG office, I feel comfortable speaking for, at least on this point, would love for you to come talk to them and to sit down with them and explain the commercial significance of whatever invention it is that you've disclosed to them, so that they can then go through the patenting process, which they have their counsel do, much what we're talking about today, but for university-owned inventions. And then if you're interested in forming a company, you could later on, you could get the group together outside the university and license out that technology and seek to commercialize it. And that is the fundamental nature as to how spin-outs from universities are established and proceed to fulfill the goal of everyone doing research, at least in part, is to bring new products and services to the world. And many of you may be thinking about doing that. And the main thing, again, is to disclose all your ideas to TGG. And at that point forward, explain to them why you want to patent it, and then preserve that ability to license it later on. All right, so the main requirements for patentability, there's 4. Whether you're working with an invention with the TDG office that was created at UCLA, or an invention created outside the university, not using the university resources, the requirements are the same. So let's go through them a little bit. So first is subject matter eligibility. This is a hot issue as of late. I'll go into it a little bit more, but the question here is, which types of inventions are eligible for patenting, right? In other words, a very narrow subset of inventions that are created are just not eligible to be patented. We'll talk about what those are. Generally, there's ways to avoid this trap, so I don't want to discourage anyone who even comes close to some of the categories, but there's a very careful way you have to go about it. Novelty is the second requirement. That is, in order for an invention to be patentable, it has to be eligible, right? One of the types, and it also has to be new. So these are all necessary requirements. They're not alternatives, unfortunately. So you have to meet all 4 of these requirements. The third is what we call non-obviousness or inventive. And that's more of a subjective inquiry. Novelty, whether something is new or not, tends to be fairly objective. A non-obviousness is an issue in every case, and it tends to be much more subjective, and we'll talk about that. Then the 4th requirement is the disclosure requirement. So in order to obtain a patent, right, as I mentioned before, by filing a patent, you are taking what otherwise was a trade secret and now seeking exclusivity for it, right? The patent owner gets the right to stop others from doing 5 things: making, using, selling, offering to sell, or importing whatever is defined by the patent for a limited period of time. So that's very different than a trade secret, right? Because as I mentioned before, if you have a trade secret and somebody else independently creates it, that's fair game. If you have a patent on something that gets issued by the government and somebody else independently creates it, they will be infringing when they make, use, sell, offer to sell, or import that invention. So the disclosure requirement is really a quid pro quo, right? So in exchange for giving the owner or exclusive licensee of a patent the right to exclude others for this limited period of time of 20 years, what the disclosure requirement ensures is that the patent owner that gets that benefit will have complied with the requirement that they take what was otherwise a trade secret and convert it into a patent right, and in so doing have adequately disclosed what their trade secret idea is, right? So what we don't want to have happen, because what it's all about is encouraging the dissemination of ideas by allowing this carrot of this exclusivity that a patent gives, to encourage people that would otherwise keep their ideas secret to file patents for them. So what we don't want is someone to get the benefit of the 20-year exclusivity right that a patent gives, while not having lived up to its end of the obligation to disclose the idea adequately enough. So it's a very important requirement. It's typically on your patent attorney to do a very good job to make sure that they've complied with this requirement. It's very much technology specific. I wrote a paper a couple of weeks ago about the written description requirement in the antibody space, which is very different than, say, the written description requirement in the oligonucleotide, siRNA or antisense space, another modality, another biologic modality, which also is very different than the small molecule space. So this requirement, written description requirement, can be very much nuanced based on the technology that you're in. It's all based on whether or not a person of skill in the art, like a researcher in the field, could reproduce and fully understand the full scope of whatever it is you're claiming based on what you've described in your patent. So a very important requirement. So 4 requirements: subject matter eligibility, novelty, inventive or non-obviousness, and then the disclosure requirement. So let's go through each of these a little bit. So what can you patent? Now we're talking about subject matter eligibility, the first requirement. So typically you can patent anything. That's the general thinking. If you look at the statute, Article 1, Section 8, Clause 8, it states that anything new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof may obtain a patent therefore. This is Section 101. This is the patent eligibility statute. That's a very broad statute, right? I read that and I say, okay, pretty much anything I make or identify or discover would fall within that. And that is true if you look at it from a statutory perspective. However, in the last 10 years, really, and we've had the same Patent Act for about 70 years now, since 1952, almost 70 years. And the first 60 years of that is Judge Giles Rich was the author. First 60 years of that, we really had very little analysis or litigation in this area. We had one or two Supreme Court cases. 1981, Diamond versus Chakrabarty, a case about genetic engineering E. coli, what I actually did some work on in undergrad, actually. So we had that early 80s case. We didn't have anything again until 2010. And since then, the last decade or so, we've had 5 Supreme Court cases on this issue. So very much a hot issue. And what it boils down to, without getting into the weeds, because it's very complicated, as to which judicially created rules preclude subject matter from otherwise qualifying under the statute. Statute itself is really broad. If you go back to the statute and read it, as we just did. So what it boils down to is really 3 areas to think about. If you're in the diagnostic space, if you're in the natural product space, that is looking at, for example, Taxol, right, was isolated from the Pacific yew tree, right, as an extract. That's a naturally occurring compound. At least the lead molecule there is. You might do SAR work from beyond it, but what occurs in nature is naturally occurring. And then the third area would be software. So if you're in diagnostics, natural molecules, natural compounds, or software, then you have to pay very special attention to how you craft your patent application, because generally speaking, those are the 3 areas that the courts are most concerned about when they're carving out what otherwise would be eligible for patenting, and for different reasons, really. The software idea is the Alice case, concern about abstractness. Diagnostic case is more of the Prometheus versus Mayo, for those of you interested in really diving in, but more concerned about patenting natural phenomena and making sure that natural phenomena in and of itself is left open in the public domain. And then natural products are the concern there is that we shouldn't be able to patent naturally occurring things as they occur in nature. And that's the Myriad Supreme Court case on the BRCA1, BRCA2 breast cancer test. So I mentioned that only because if you're in any of those 3 areas, you have to pay very special attention to how you do your patenting. But that's not to say that just because you're in any one of those areas at all, are you precluded from filing a patent? You're not, right, at all. We're filing patents in all three of those areas every day. And there's now guidelines that give us a little bit more clarity from the great work that Director Ionku did before he recently resigned. I've been very pleased as to the effort. I still think there's a lot of ambiguity in the space, and that'll get worked out. But it's really on your attorney to sort that out. But the main point is if you're in any one of those three areas, you have to pay very special attention to Section 101. So that's the first requirement. The next requirement is novelty. This is a little bit more straightforward. I think it makes sense that nobody should be able to patent something that somebody else did. So when it comes down to what you can patent, your patent ends up having a set of claims at the end. And picture the analogy here of a puzzle. If your claim is on the right-hand side and the asserted prior art, that is a single reference that came before, on novelty and whether it's new, we have to only look at a single reference. We can't combine references. So take a manuscript from yourself, if it was more than a year ago, or anybody else that authored it before you filed your patent. And if all of the elements shown as puzzle pieces in your claim are shown and appear in that single document, it could be a single website, it could be a paper, could be an earlier patent. If all of the elements in your claim are already described in that paper, then you will not get a patent because you haven't complied with the novelty requirement. All right, so you may try to add in a fifth puzzle piece to this on the right-hand side. And if that fifth puzzle piece was not in the single document, the prior art, then in that scenario, then you would have complied with the novelty requirement. So to comply with novelty, the second requirement, you really only need a slight change from what has occurred before. And you can only look, the examiner, when they're examining the patent, or a defendant in a case, can only use a single reference for novelty. You can't combine two references together. So let's just assume for sake of argument that the four elements in the claim were in the prior art reference that was available before you filed your patent. But you then add a fifth element, and therefore you've complied with the novelty requirement. Now in that scenario, the question would be the third issue, right? Because all of these are requirements. The third issue now is, okay, so your claim is novel. Is your claim not obvious, right? So is adding that fifth element to the puzzle that was not in the earlier paper, is that something that a person working in this space would have routinely done on the one hand, or is it something that was so thoroughly described in a different reference, right? Because it wasn't in the first one, and under novelty, you can only look at one. So we established that it's novel, but is it inventive or is it non-obvious? This is why it's more subjective. So the question here is it routine in the workmanship of someone in this space, or is it something that somebody would have been led to by way of it being so known in the field, right? That you would look to a different reference and somebody would combine the two together to come up with that fifth piece. If the first puzzle or the first reference that you cited has four of the puzzle pieces, and all you're missing is the fifth, maybe there's another reference out there that somebody working in this space would be led to combine the two together to arrive at your five pieces. And the way that you do that is you have to go back in time. You can't use hindsight, right? And it's really important that when that analysis is done, it's done from what we call a person of skill in the art. So consider somebody with 2 or 3 years of postgraduate research, typically in the space. It could, depending on the level of skill, it can vary. But the point is that person has to be have the invention in front of them on their desk, as shown here in the slide, with all of the references that are out there on the walls. And they have to ask themselves at the time when the patent was filed, not today, and I'm dealing with this right now with a lot of COVID inventions where, you know, COVID's been on the top of everybody's mind every day when they wake up. So it's really hard to remove the hindsight bias that is inherently present in everybody's thinking. So we have to go back to say, you know, I had some clients file some stuff in February last year, and we have to go back in that time and think about whether or not at that time what we've invented would be obvious, not whether or not all the information we have now would the invention we created a year ago be obvious. So that's That's a very important criteria. And there's no reason why the examiner, when they're doing this analysis, has to start with one particular reference. In fact, if they're combining two together, which is normally what happens in an obviousness analysis, they need to have a reason why they would be led from one to the other. So this is very subjective, right, by its very nature. And here's where this third step of non-obviousness is where most patent attorneys are really going to earn their pay, frankly, by coming in and helping to convince the examiner why an invention that today, as we're working through it in the examination, may appear obvious, really wasn't obvious at all when it was filed. And there's a lot of ways we can do that. Data is very helpful if we come up with some unexpected results, if we have a wildly commercially successful product, or if we have licensing by others. There's a lot of objective criteria that we can look to help inform what otherwise appears to be a very subjective analysis, at least at initial rejection, which we uniformly always get, an initial obviousness rejection from the examiner. We have lots of ways to overcome that.
So I've got a question, if that's all right.
Yeah.
Thinking from the examiner's point of view, what is their standard of calling something obvious? Does it vary from examiner to examiner, or is there like a rubric that they follow?
It'd be nice if there was a little bit more of a rubric, but it's very subjective. There's a four-step process to the obviousness consideration. The first step is understanding what the level of skill in the art is for the space that you're in. If you're in a technology field that is truly pioneering, like molecular biology, maybe in the 80s and 90s, at least from my perspective, was very new at that time. So the level of skill in the art was fairly low, right? So if there's a lower level of skill in the art, then the invention, I would say, can appear to be not as a significant leap and still be invented. Whereas, if Thomas Edison is the level of skill in the art, from his perspective, anything's going to be obvious, right? If you're that smart and you look at anything that's been done, you're going to be like, oh, of course that's obvious. So figuring out what the level of skill in the art is the first step. The second step would be understanding what is in the prior art, right? The scope and content of the prior art. So in this scenario, looking at the wall and understanding all the references that are out there. The more crowded the space is, the more prior art out there, the more difficult it will be to get an invention that is close to that patent, which probably makes sense. And then we look at the differences of skill in the art, differences between the invention and the scope and content. And then the last requirement is what we call objective indicia of non-obviousness, where a lot of those objective factors I was mentioning, like if we can show unexpected results, for example, if we can show that our molecule, our therapeutic molecule that we've created, that the examiner is saying is obvious in view of an analog, if we can show that our molecule compared to that analog performs exceedingly well in a surprising way, and normally it's surprising because it's really hard to predict what a molecule will do in an in vitro model, let alone an animal model. So if we can show some decent data, unexpected results is a great way to answer your question directly, what can be a scatter of approaches. Typically, if you have really strong data and your only rejection is obviousness, that is, you've showed it's new, you can get a patent on that, irrespective of who the examiner is. There are some crazy examiners, I won't say who, but we've all worked with them. And bless their hearts, I think they think they're doing the best they can. But at the end of the day, even with them, if we can sit them down and show and walk them through, we used to do it in person, which I think was great, but the virtual Zoom stuff works too. We can sit them down and show the data side by side. It's really hard for them to then maintain that rejection in view of that type of data. Same could be true for a commercially successful product. Really, these objective considerations are a great way to kind of bury the hatchet with the examiner. You can also argue the other points I mentioned. You can argue that it's a really low level skill in the art. You can argue that there's not a lot of prior art out there. You can argue that the differences between your claimed invention and the prior art that is out there is very wide, right? There's nothing close, and we do. But at the end of the day, really good data, objective data, will allow the examiner to feel like they've done their job, to essentially concede on the point, even if you don't admit that. You say, look, we'll agree to disagree. But in any event, we have some really good data here that even overcomes your prima facie case of obviousness. It's a really good question, and gave me a chance to walk through the analysis. But it is definitely examiner specific, and I think there's a way to normalize it if you approach it the right way.
Thanks, Matt.
Sure. Cool. So that's the main parts about the requirements for patentability. In a university context especially, I always like to reinforce the need to file. So always file at least a provisional patent application through the TTG office way before you ever want to publish or discuss or talk about your great ideas, right? Because if you don't, especially ex-US in Europe, and to a certain extent in the US after a year, but don't rely on that year. But if you don't, generally the rule that you should think about is your own work will be used against you, right? So your own work could actually be used as a novelty destroying reference, right? So if you go back to the second requirement here, if you publish a paper and definitely more than a year before you file, and in any event, if you publish before you file in Europe, especially even a day before you file, then your own paper will be used as a prior reference against your own invention, right? So if your patent is the same as your paper, you can see how there's probably going to be problems there if you let your manuscript get out there before you filed your patent. I mentioned there's a grace period in the US. Don't rely on that. The grace period is not I even wrote it here. It's not a strategy, but a fix. So don't rely on the grace period. Disclose your idea to the TTG office. Sit down with them, explain to them why it's important to you, encourage them to get a patent on file. Once the patent's on file, then we all understand the currency at a university to publish if you need to. Just make sure that you do so knowing the consequences, right? And the consequences, if you haven't filed a patent, may be that you don't get to get a patent on it, or only in the US, in which case that may not be commercially attractive enough to a partner to want to license it. If you really are interested in your inventions being commercialized, it's really hard to commercialize a product if you don't have a patent on it to help you raise capital to get there, just as a factual reality. So very important. That said, we all understand the currency at a university of publishing, very important. All right, so let's talk about developing a lifecycle strategy just briefly. When we think about the timing for when we file, again, file before you make public anything. The main point here to think about is it's a process. It's an examination process back and forth. You file your original provisional here at year 0. Over the next year, you may update that. The provisional gives you the ability to modify the application if you'd like to, and ultimately file the non-provisional at year 1. That non-provisional is what gets examined by the patent office. These days, if you want to have that be a quick process, there's ways that we can do it. We can actually accelerate examination in the US, and we're getting patents issued as quickly as 3 or 4 months from when we file. Average maybe 6 to 9 months. Great process. Historically, as shown here, it would take, say 2 years before you start getting anything issued, which is still the case under the traditional slow route. At this 1-year anniversary, we also file what's called a PCT application. The PCT application allows you to then file international patents another 18 months later. So it essentially defers, by filing that PCT at the 1-year anniversary from your first filing, it allows you to defer another 18 months, so a total of 2.5 years, or what we call the 30-month deadline, to pick the countries as to where to file. So our normal approach would be at the 1-year anniversary, file in the US, file a track 1, get that accelerated application going, try to get an issued patent in less than a year, and also file a PCT application that will then allow you to defer the cost and expense of filing internationally for another 1.5 years. I skipped over step 3, not on purpose necessarily, but just to illustrate the deadline for the PCT. But before that, and 6 months after your non-provisional, a total of 1.5 years from your provisional, you're going to have the publication of this application. So just keep that in mind. To the extent you have any improvement applications to put in, the time to file those would be before publication. If, especially in a situation where you haven't already published a manuscript corresponding to the patent, you would want to file incremental improvements, if you have them, prior to publication of the first patent, because just like your own work can be prior art to you, anything that publishes, any later patent filing, the earlier publication will be prior art to that as well. So now you're starting to think about an overall strategy of a portfolio, right? So when we think about an IP strategy, we want more than just one patent. Maybe the first patent is the university patent that we in-license, but we want multiple. Maybe the second patent is as well. But by the time we get the product to the market, we would love to have 3 or 4 or 5 different patent families that cover different features of that product, all designed to increase the upside for everybody that's involved, right? That is to maximize the return for the investment, the significant amount of investment that's made by UCLA, by the company, by everyone along the way. All right, and that's what I've shown here, the different patent families. The second patent family, maybe the first one is the platform that you license, maybe the company is then spun out. The patent would be filed before publication of the first, and the third would again be filed before publication of the second. Now, these are all different patent applications, to be clear. These are not, continuations for those of you familiar with that. These are different patent families altogether, entirely new specification, new idea, protecting a different aspect of what that invention is. But the goal would be that we don't have to deal with the earlier patent family as prior art, if it's close, because we filed the application at issue before its publication by filing it before 18 months from the earliest provisional. All right.
So Matt, can I ask a question about that?
Yep. What
drives that process? Is that actually a direct consequence of engineering developments and you continuously just publish?
Exactly. So exactly what drives it. So you have your initial idea filed, right? Your conception patent with maybe a little bit of data, enough to know you want to file. That's filed as a provisional. So any additional work that you do over that first year, you would add into this same application in this same patent family. At the 1-year anniversary, you can no longer do that. You can no longer add new ideas to the specification of that patent, right? So it's now, think about it as concrete being set. The concrete is still wet up until the first year anniversary. It's then set. So you can't add new ideas. So if you do come up with new ideas, hang on to them, don't publish them, but file an entirely new provisional as family 2 just before publication as the engineering develops. And inevitably, you're going to come up with additional ideas between 1 year and 18 months, such that you do want to file a new application. If there's nothing to file because there haven't been any new engineering developments, perfectly fine, right? Nothing to file on. But if there is, that's a nice last chance to file before the first one becomes prior art to you. And now you have a second patent family filed 18 months, almost 18 months from the first. That also gives you an additional patent term beyond when this one would expire, right? You're adding another 18 months on the back end. So there's 21 years from your provisional or 20 from your non-provisional, right? Same would apply here. But yeah, it's driven by engineering developments and just the timing, like aligning up your engineering or your biotech development, whatever it is, with your patent filing strategy. And I have some more slides in here showing different. This is a class 2 medical device example that interplays a little bit about your 510K review. This is a PMA medical device example, the highest level of FDA review that also gives you some patent term extension ability, which is quite nice for one patent that covers the product, but typically is a longer process for development. This is a highly invasive therapeutic companion diagnostic approach, for example. And then the drug product, there's no greater scrutiny or rigor than that, right? So in this scenario, we might have 5 or 6 patent families. Just took a company, Prometheus Biosciences, company I spun out of Cedars-Sinai in LA, just took them public. And along the way, we have 6 or 7 patent families protecting their core antibody that's nearing the end of phase 1. So here 3 are shown, but you might have 6, 7, 8 and a very long and exhaustive and intensive FDA approval process, which will lead to patent term extension here. All right, so just very briefly, because I do want to leave time for questions. FTO, we haven't touched on that. Up until now, we've really been talking about developing a patent portfolio that protects the product or service. Just briefly, the FTO process allows you to have some visibility as to whether any third parties have patents that you may need to get rights to, right? So I think about it as turning, especially in the university context, turning a risk into an asset. So if you, a lot of times when we're doing FTO work, we may identify a third-party patent in the landscape that is owned by a university that we didn't know about. We can then contact them and try to turn that risk into an exclusive asset, if possible, if it's not already licensed. The same would be true for other patents, although if it's a company patent that's competitive, it might be harder to get that because it's already taken, so to speak. But this is work that we do at the attorney level. I don't recommend that you do much self-help in the FTO space because learning about the identification of a patent out there that you infringe, for example, can haunt you down later. Because if you learn about that outside of the privilege setting, that will become discoverable in litigation, if there ever is litigation. And if your product is wildly successful, somebody will copy you, there will be litigation. If you have notes out there that talk about a third-party patent that you might infringe, that could become discoverable if it's not done at the advice of counsel. So it's generally something we do at the attorney level. However, it is very much interactive with the client because you all know the technology the best and can help us thoroughly search the landscape to identify the most relevant patents. So with that, Matthew, maybe I'll turn it over to any questions. So just answer that one, the patent expiration question.
Yeah, if you don't mind.
Sure. So patent expiration. So that goes back to the quid pro quo of the disclosure requirement, right? So what we're trying to do with the patent system, and this is the same for all other systems modeled after the US now, which is the case, what we're doing is incentivizing the owner of an idea who has it as a trade secret to file the patent. So we're incentivizing that person to file it with the carrot being if they get the patent issued, a 20-year patent term from when they file their non-provisional application. If they take advantage of the full year, it'll be 21 years from the provisional. And there's it's somewhat of an arbitrary number. Why 20? There's been a lot of studies, but it seems like it's here to stay. But the main point is the expiration is important because if the patent never expires, then the public will never be compensated for giving the owner the exclusive right to the idea, right? If you give them the idea forever, then why would we ever encourage somebody to file a patent from the public perspective? The whole idea is after that patent expires, the public will be better off because everybody will have access to that idea that would have never been made public if we didn't incentivize them to take a trade secret and file a patent on it.
Thanks for that. I got another one that came in through chat. The question is, how much of this has to be done before we can raise money?
Very good question. The strategy needs to be done. The thinking through what we're going to do and when needs to be done. And when you say raise money, let's just break it down. So you could raise some money on like a SAFE or a convertible note of a couple $100,000 and not expect to get any IP diligence and not even have an IP strategy. At that point, they're probably just investing in you because it's your great uncle or something, friends and family. You don't need much then. Before you raise significant, considerable amount of money, let's say like a seed financing of 2 or 3 million or more, you can expect to have a significant IP diligence call. Companies that I would think 3 or 4 years ago were raising, $700,000, maybe 500,000. I'm seeing are getting 3 to 5 million, which is pretty impressive. And as I opened up my talk, those investors are expecting those companies to have a well-established IP strategy that's at least thought through before they're going to give you that amount of money, even if your business is at a little bit more nascent stage where you wouldn't expect to even have to do this yet. So that doesn't mean you have to have everything figured out or the entire portfolio built. but you do need to be able to get on a phone call with them and sit them down and say, here is our IP strategy. Here is what we're doing. We're early on. We've filed this patent that the university filed for us. We're licensing it. We have an option or a term sheet. We're in the process there. We're pretty close. They'll probably make you finish the license before they close the deal, but you have that going. And by the way, once we have some more funds, we plan to then obtain lab space outside, the technical laboratory maybe at Magnify, for example. We plan to hire 3 or 4 people. Those 3 or 4 people are going to be full-time employees of the company that are going to take this platform idea that we licensed from UCLA and improve upon it. And we hope to file additional company patents that we own by the company once that work is done. In addition to that, we're going to start looking at some FTO work. We've already identified the main players in the space, and we know what patents they have. As we go forward, we'll do more robust searching that's appropriate for the stage that we're at. So you got to be able to get on the phone and talk to each point, but by no means do we have to explain, or would I if we weren't there, that we've solved every issue or boiled the ocean. The more amount you get, like if you're upwards to 3 or higher, you probably want to be able to start to convey that you really have dug in and looked at all the patents, not just who the main competitors are, but you've done keyword searching out there to know what other landmines are there, and you've already started to really file your own patents as well. So it's really the amount of work is directly related to the stage that you're at. But again, I'm seeing more and more higher valuations, higher dollars coming in, and those investors don't change their level of diligence based on the stage of the company, even if they are investing at an earlier stage than they ever have before.
Makes sense. We got one more question. I think we have the time to answer it if you don't mind.
Sure. I can read it too. Non-PI supporting staff, for example, grad students who are listed as co-inventors on the patent, have any roles in future patent litigation and licensing agreements? Yeah, I mean, non-PI staff members oftentimes, if they decide to leave the university, can become key role players. So the question, I didn't actually read the question except to myself. Do non-PI supporting staff, for example, grad students who are listed as co-inventors on the patent, have any roles in future patent litigations, licensing agreements, et cetera? So the answer is yes. I mean, I would say even aside from litigations, which may never happen, and if it does, it's going to be down the road. Licensing discussions, yes, if especially if they're involved with the company, if they decide to leave and take a role at the company, maybe as the early CEO before the company needs a professional CEO, or maybe you're a professional CEO and you're the person forever. So absolutely, yes, that's a great source. In my experience, rarely do PIs leave. Some might take a sabbatical. We've had that at UCLA a few times, but 99% of the time, no one's leaving on the PI side. But the grad students, postdocs, maybe. And in those scenarios, you might be the one on behalf of the company, provided that you've left the university formally. You could be the one that's leading the negotiation. And also, if you're an inventor on a patent, perspective of where you're at, you very well may be involved in a future litigation in some capacity. But in the near term, I think it's postdocs that are interested in starting a company based on the technology they worked on with their PI is a great source, in my view, for an early business person to run the company, which, by the way, oftentimes is the most difficult hurdle to overcome in what we call the valley of death of spinning out technology. It's not so much the money, it's not the IP, it's just getting the right people to run the company early on. And actually spin it out, right? An actual true spin out, not talking about like a hobby in the lab. I'm actually talking about a real company that has licensed the technology and is actively looking to commercialize. That's what I've seen be the most successful path towards commercializing university technology.
Thanks for sharing that. That's the point that we're trying to get our guests on the call to. So thanks for your insight and wisdom. And to our guests on the call, please join us every Friday this spring for the Entrepreneurs Bootcamp for more further insight. Matt, you've got your contact information up here. If you want to give it one more call out, just in case folks want to reach out.
Yeah, sure. So my email is my first initial M and my last name, Bresnahan, Bresnahan wsgr.com. And my direct dial in my office, 858-350-2226, and would love to speak with any of you about any questions you have.
And if you have any further questions or need any connection to different resources, please make sure that you reach out to New Ventures. Just search UCLA Startup in a Box and you can find resources there. Thanks so much and join us next week.